in some ways it is a little early to say in terms of the big project that I was talking about, but one area in which we've kind of piloted this ahead is in the health sector. So we've worked with the NHS there and piloted health inequality and human rights impact assessments. And the process that they've developed there, I think, has helped to mitigate that risk, because the culture in Scotland, as no doubt elsewhere, is that public bodies look to their lawyers for questions about human rights. That they're, unlike with equality, where the positive duty to promote equality has filtered through into a sort of proactive engagement with those concepts. How can we, in what sense is this decision likely to lead to indirect discrimination? How can we use this to foster equality? That hasn't happened with human rights. Human rights is the big legal threat of going to court and getting a finding that will lead to compensation. But the process of integrating it into decision making at the sharp end in health has mitigated that risk. So it's screening first of all, which is just in a first initial look. Do there appear to be human rights issues engaged here? Yes, then we carry on. Scoping, which involves all of the professionals who have an input to actually look at, well, whether that is a real risk and how it can be mitigated. And then evidence collection to see, to actually look at whether that initial thought is sustained by evidence, and then informing a change in practice. So we've seen that play out in a number of different areas. For example, a move towards community wards, driven in part by austerity, so moving people out of institutions to receive care in their own homes and in communities. Then there are obvious human rights engaged there, for example, the right to the highest attainable standard of health, but also private and family life, a lot of people entering people's homes, etc. So thinking through how that can be done and the policy objective achieved in a way that takes account of the human rights impacts, and then tweaking the policy in response and ensuring protection from abuse in that context, and also some other changes that resulted. So it's taking it away from the lawyers and giving it into the hands of the policymakers and multidisciplinary teams.
Okay, thanks, Duncan. Yes, Mark, and then that gentleman.
Thank you. Well, I don't think it's a particularly brilliant question, but I'm hoping for a brilliant answer. I wanted to come back to the question of strategies for change in a political context, and it's a question primarily for our Scottish colleague, Duncan, although Michael might have a comment on it as well. I was very struck by the fact that you were emphasising the tendency of bodies that are campaigning or working for political change and strategic change to be reactive rather than proactive. And you mentioned, it was on your slide, the case of Castell against the Scottish ministers, but you didn't really get into it. And the reason I'm coming back to it is that, and this alludes to something that the Ombudsman touched on as well, there are situations in Ireland where we know for sure that there's a human rights violation in existence, but nothing effective is being done about it. And we are currently in Ireland in exactly the same situation as you were in Scotland prior to the decision in Castell against Scottish ministers, which is to say we know for a fact that a lawyer can't be present during police questioning. The Department of Justice know this. There's an expert committee supposedly meeting in secret within the Department of Justice, but there's no actual proactive action being taken at an official level, at least, to move into compliance with what we know is an extant violation of human rights. We don't even have to go to the European Court of Human Rights to look at Sabus against Turkey. We just have to look across the water at Castell against Scottish ministers. It's perfectly clear it's a case waiting to be won, and the Department of Justice know that. So, I mean, my question was, in that context, and coming back to alternative strategies for change, what do you think, drawing upon the Scottish experience, national human rights institutions can do more effectively to promote the delivery of change in a proactive as compared to a reactive way?
Okay, I'm just going to take briefly that question, that gentleman, and that will be it for the session before I release you to your food.
Thank you, Chairman. Poor Kenneth from England. I want to come back to a favourite hobby of mine, that is national action plans. And again, unfortunately, Duncan, you're going to be in the Parliament. We all agree, and I think we're all very much aware now of the importance of national action plans for human rights from 1993 onwards. But I want to put this a little bit in an Irish context, because
briefly, please.
We seem to have a remarkable ability in this country to produce action plans and strategies. And in the last 10, 15 years, we have produced literally mountains of them. Social inclusion, disability being some of the most recent ones. None of them have any legal status or can't be decided in cases, remarkably. They're gobbled up in policy, they're part of endless consultation processes and results, and at the end of the day, the beneficiaries are left looking bewildered as they're told their rights are safe. What I want to ask you is, how do we give these national action plans some teeth so that the beneficiaries, if there are beneficiaries, can use them effectively?
Martha, perhaps if you could address the first question.
Okay. Well, just on the question of solicitors being present, it's a question by the charge. Some of the criminal lawyers should take the case straight away. There are some difficulties about that, maybe because you have to be sure that you're taking the best case and that the client isn't going to be such a very unpleasant individual that may prejudice the judges somewhat. The other thing is that the Human Rights Commission has the power to take cases and could cut through things quite fast by taking the case directly. The Commission has the power, it's not done it so far, to take the case in its own right. But that presupposes the Commission would be able to do that. And the, don't want to stray too far from the question, but the Human Rights Commission and the Equality Authority are basically being gone into the ground of the law. The Human Rights Commission has 6 staff at the moment. It is complemented by 20. The Equality Authority's staff are being away at the same rate. And unless these bodies are put back together very fast and given additional resources, they won't be capable of doing anything. So they won't be capable of taking that sort of case when you go back to the individual lawyers. But yes, I mean, in a situation like that, it's necessary to be proactive, to take a case. The jurisprudence is clear. It happened on Section 62 of the Housing Act, where actually a Supreme Court judge indicated that this was a breach of the convention, but at the time he gave the decision, the convention hadn't been incorporated. So the obvious thing to do was, when the convention was incorporated, take the case, and the cases all, the group of them all succeeded. So it's there to be done. But we need the institutions. We need that extra thing to have the institutions that have the capacity to take cases in their own name, because there's some circumstances in which that's very important. And unless the government is prepared to give much greater resources to this new body, it's not going to work.
Okay, Duncan, very briefly, and then you can continue with the lunch.
On the first question, very briefly, auditing of the legal landscape would be useful. I'm not sure NHRIs have the budget to do that, but government has an onus and it would be in their interests. Looking at decisions before they're made and assessing the human rights impact to save money apart from anything else. We had a political decision not to invest £13 million in moving away from slopping out that led to a compensation payout of up to 70 or 80 million. That was a failed decision-making process from a financial point of view. Our work in the mapping to develop the action plan points out areas in which preventative spend could lead to invest in human rights could lead to a reduction in costs at the end. Investing in public health to reduce the cost on health care, for example. Investing in violence reduction units and similar initiatives to reduce the costs on detention and prisons. These are ways which are very much in the human rights spirit, which can lead to a reduction in public spending at the end of the day. Or simple measures like apology laws, which lead to a reduction in civil litigation. When you pass a law saying you can apologise effectively, we're sorry that happened to you and we take responsibility, without fear of civil litigation, without fear of an insurance company voiding an insurance contract, it reduces, as Australian experience shows, civil litigation. That's in the public interest and reduce costs. Second question, very briefly, action plans are no alternative to incorporation. They should lead to incorporation, but other ways in which they can be taken off the shelf include processes which involve the broad civic society that recall to hold to account the duty bearers for whether they have done what they said they would do, and also linking it with international accountability mechanisms. In our case, an impetus and a hook is the Universal Periodic Review, but obviously treaty bodies, regional bodies as well, and of course engaging those international human rights actors to show the world is watching.
Okay, thank you very much. Thank you, gentlemen, and thank you all for your attention, and enjoy the rest of your afternoon. Thank you.